Welcome to the Divorce Duo. I'm John Knocklinger.
And I'm Christina Previtt.
We are partners of Previtt and Knocklinger, a law firm in central and northern New Jersey. We devote our practice to divorce, family law, and related issues. You can find us on the web at centraljerseyfamilylaw.com. You can follow us on Facebook, on Twitter, on Instagram, on LinkedIn, on what other sites can you follow us on? Basically anywhere on the internet.
Twitter, Instagram.
Yeah, Twitter, Instagram.
There's probably a lot of other ones that we don't know about because we're old.
Yeah. I don't know
like Tumblr? What is that? I don't even know what that is.
I don't know. I think that's something the kids are doing these days.
Kids.
Yeah. They're the kids. You can also contact the show at divorceduo@gmail.com, where you can ask any questions that you want to ask, provide any comments. You can tell Christina how wonderful she is.
Mm-hmm. You could always do that.
She likes those.
You could tell us we're doing a terrible job.
Yeah, well, we may or may not have gotten some of those emails.
We just ignore those.
Just ignore those. Delete.
There's always going to be haters.
Yeah, haters gonna hate. So how are you feeling today, Christina?
I have a cold.
Yeah, I know. I've been watching you down Dayquil.
I'm kind of grumpy.
Well, I thought it was interesting. Earlier, you told me you went to buy Dayquil and they carded you.
Yes, I don't remember ever being carded for that.
And of course, my immediate reaction was, I can't believe they even thought that you would be too young to buy
So, yeah,
Dayquil.
I either suddenly look very young, which there are some explanations for that we won't go into, but or I look like a meth addict, or
I'm not sure either one of those is a good thing.
I have a meth kitchen in my car or something like that. What do they call them? A meth lab. That's what they're called.
God, really? Well, we hope you can get through this show. Okay.
Yes. Otherwise, I'll just have you do all the talking and, Oh, we are drinking wine again today because that worked out so fabulously the last time.
Yeah, we don't have such a wonderful excuse like it's St. Patty's Day again. We can
We don't need an excuse.
It's a Friday afternoon.
That's right.
We're taping this on a Friday afternoon, so I guess now you know.
Yeah.
So
we feel that we're much smarter when we're drinking, so I'm gonna roll with it.
It's true.
I think it is.
It's a true story. Well, so all right, so let's get started. We're going to start with what's in the news. So we got some interesting things that we've been finding out around the country that should make you feel thankful that you live in New Jersey. So in Florida recently, they just passed a law to repeal a law that's been on the books since 1868 that prohibits a man and a woman from living together. And if they are living together, it could result in a fine of $500 and being locked up for up to 60 days.
Well, what's interesting, though, is it has to be a man and a woman. What about a man and a man or a woman and a woman?
I don't think in 1968 they were really thinking about that.
Well, but technically,
I mean, obviously,
those are the laws on the books, right?
I mean, obviously, in ancient Greece, they were doing all kinds of stuff, man on man, woman on woman. They didn't even care about it. But yeah, in 1868 in Florida, I don't think they were really thinking about that. But it's interesting. This article says, according to the 2014 census, there were 438,000 unmarried male-female couples living in Florida.
I'm surprised they didn't find them.
Yeah, that would have been a lot of money for the state.
It would have been. I mean, we all know that's why, we get pulled over and get tickets and things like that.
Right.
Revenue.
So anyway, so that's been repealed. So big win to the people of Florida. You can live in, sin now. It's not a big deal anymore. So
I mean, is there a lot of that going on down there? What other sin is going on down there?
No,
Isn't everybody retired?
Yeah, that's what it sounds like. Staying in Florida, so there's been a movement afoot around the country to reform all the divorce laws, and that's both like alimony statutes and custody statutes and all these other parts of divorce. In New Jersey, of course, we've amended our alimony statute, which we discussed in a past show. You can go on to the YouTube page here at panjradio.com, and you can watch our show where we talked about alimony. But in Florida, they're really the most recent big state to start doing this, and they are seeking to get rid of permanent alimony, which we've done in New Jersey. I think that's popular now.
Well, I always have to take a step back when people say we got rid of permanent alimony, because in my opinion, it sort of functions the same way what was put in place of it, the open durational alimony, but maybe that's another show. It's just not called permanent, and it functions a little bit differently. So do you happen to know, are they doing something like that in Florida? Are they replacing it with something else, or are they completely eliminating the concept of permanent alimony?
According to this article, in Florida, what they're doing is they're going to institute a formula for alimony. So formula based on incomes and on duration of the marriage. So,
Which I would guess might be something they've probably been doing informally anyway.
You mean we don't do that here?
Yeah, no one does that here.
I know Massachusetts also has a formula for alimony, but they've already encountered some issues, and they're having to amend their statutes again to try to fix those problems. But the other thing that they're doing in Florida, which I think is going to happen here soon, there are statutes that have been introduced, or bills that have been introduced, not statutes, to create a presumption of there being joint custody of children.
I like that. Because, I mean, I don't know that everyone has functioned that way so far. I know it depends what judge you're in front of. There are some judges that are just sort of notorious for thinking that 50-50 custody is the way it should be. And then other ones that are pro-dad or pro-mom. So at least this will provide some uniformity, so you know what the starting point is when you go in front of any judge.
Oh, I agree. I mean, I know here in New Jersey, the family law section of the state bar is fighting any of these kinds of statute changes because, it creates more uniformity, which is less room for arguments for attorneys. So I think a lot of people, it's all under the guise of it's not really going to be fair, particularly to women. I hear this argument all the time. It's not going to be fair if all of a sudden, like the husband's going to have that presumption of there being 50-50 custody when maybe a wife stayed home and cared for the children. But it's a presumption. It can be overcome if there's some reason there shouldn't be joint custody. You can overcome it.
That's right. And just so listeners understand, just because there's a presumption doesn't mean that there's no way to have it deviate from that. You just have to demonstrate the reasons for that, and that you always have to consider what is in the best interest of the children.
Absolutely. I mean, presumption just means that unless you prove otherwise, that's what it's going to be.
That's right. And interestingly, there are plenty of dads that want 50-50, but there's plenty of dads that don't. And you know what? There's plenty of moms that don't. I've seen that often.
Yeah.
Where the moms don't want to be the primary parent.
They want that night off.
Yeah, and I
that
don't fault them for that. So it'll be interesting, though, because the parent who doesn't want the 50-50 is going to have to say that no, it's okay, you can have the kids more often, which I don't know, might be a little uncomfortable to have to say that.
Oh, I agree. So in other news, this should excite you, Christina, who's constantly got her foot on like a rock on the pedal driving around.
I thought you were going somewhere else with that. Thank you.
Oh, I don't even want to know. So you'll be excited to know Pennsylvania has raised its speed limit to 70 miles per hour.
Great. So we're even closer to 100 than we were before.
Now for the bad news. New Jersey said that they are not raising their speed limit past 65.
Why? Do they give some rationale for that there?
Because they're idiots. That's why. I mean, in most roads in New Jersey, the speed limit's only 55 miles an hour. It's only 65 miles an hour, like on the Turnpike and parts of major highways outside of the urban areas. I mean, like the Parkway, I think it's 55, almost the entire length of the Parkway, until you get down into Monmouth County and Ocean County. I think it might increase to 65.
But do they really? I don't know how they enforce that. Have you ever gotten pulled over for going 70?
No, I go 70 routinely. I've always taken the philosophy that, everyone on the road's passing me, going 80,
It's
90
true,
miles an
yeah.
hour. I mean, but I think it's a little silly to drive 65. I mean, no one's going 65.
I tend to think that you have to be going 80 or more to get pulled over on those major highways. I mean, this is
Do
not
you-
legal advice,
Do you
though.
have firsthand knowledge of what it takes to get pulled over?
Perhaps. I've had a few scares where I was going 80 or more past. I didn't see a cop that was on the side of the road and thought for sure I was going to get pulled over, but I didn't. But everybody else was pacing me, so I wasn't going any faster than anyone else.
I got a ticket on 78 for going 75.
What?
Oh my God.
And everybody else was going 75. I was in the traffic and they just pulled me over. I was the last one in the row.
Well, you know what you needed?
Was the cop young?
Yes.
Yeah, I don't. I mean, not to generalize, but I'm going to generalize. I think sometimes the younger officers just, I don't know, they're going to save the world. They're not tired yet, like us, like old cranky
He was in an
divorce
unmarked
lawyers.
car and he came right up on my, right behind me, like tailgating me. And I thought he was like a total jerk driver. So I was like telling him, I was giving him like, come over, go around me, go around me.
And he
And
turned
then
on
he
the
hit the lights, yeah.
Wow. Those unmarked cars scare me. What's the number you can call if your unmarked car's pulling you over? It's like,
I don't know. I haven't
it's not
heard that.
it's not 411. It's like 511. There's some number. I just happened to see it recently. Like if you're, because if you're being pulled over by
Yeah.
an unmarked car, there's been people that
Yes.
haven't been cops that have been
I
pulling
would
over.
be concerned about that. I would be.
That would be too. I mean, someone wants your driver's license and they're writing down all your information.
Yeah, you never know.
People are so scared when they see the lights anyway. Most people just shut down.
I know we should probably have another show on that topic, but there's certain things you don't have to give consent for. I'm always amazed why people sure, search my car. You can look in the glove box. You can look in the trunk.
Yeah, and
And then they find weed. It's like, well, why did you let them search the trunk
course-
if you had weed in there?
Oh no, the cop. Whenever you say, "Oh, search my car," they're like, "Oh yeah, here we go."
Yeah.
It's like, you moron, complete and utter retard.
Okay, be careful with that
Yeah,
word.
you know what? I'm not PC. Anyone who's listened to the show knows that I'm not PC. I don't really care. I'm not as bad as my dad.
Oh, yeah, we won't go there.
You know what? I'm over this whole PC thing. I think we went overboard in the country going to PC. Now I'm not Donald Trump on PC.
Oh, I was just about
but-
to. It's funny you said Donald Trump because I was thinking, really, have we? Because I thought that went out the window with Donald Trump.
Yeah, I know. Well, you can tell his picture that hangs over your bed at night tonight what you think about his PC. But anyway, on to our topic of
Yes.
the day is top 10 things you need to know about temporary restraining orders. On our next show, we're going to be talking about the top 10 things you need to know about the final restraining order hearing. So this is sort of the beginning of it, and we'll finish it next week. So you got to tune in both weeks if you want to hear it all.
That's right.
So why don't you get us started, Christine?
So we just want to point out, too, that there's a distinction, obviously, between the temporary restraining order and the final restraining order. So today we're going to focus primarily on the temporary restraining order. So where, when, how? Sort of some overlapping information, but generally the plaintiff, the one that's making the application for the restraining order, can make the application where he or she resides or where the defendant resides, or the statute allows him or her to make an application where they may have retreated or found shelter if they're trying to get away from the person that's perpetrating the domestic violence.
Or where the act occurred.
Yes, or where the act occurred. And in New Jersey, and I would think that other states are similar, if you had to leave another state and flee to New Jersey because of that reason, you can find relief in the state of New Jersey under those circumstances.
Or conversely, if you're vacationing on the Jersey Shore and there's an act of domestic violence, you can get a restraining order in New Jersey because New Jersey might have more favorable laws than wherever you live. So we really give everyone that option to get a restraining order here if it happened here. So
Certainly.
So where are they issued? The temporary restraining orders.
Well, to address the when, is that what you're talking about, John? So this is something near and dear to me because we get so many clients that will call us and say that they tried to make an application for a restraining order at the police station and were told that they couldn't. I lose my mind when that happens. Generally, if you want to make the application between the hours of 9 and 5, normal business hours on a weekday, you should go to the courthouse to do that. Not the municipal courthouse, the superior courthouse in the county where you'd like to make the application. If it happens any other time, meaning if you want to make the application, not necessarily did the violence happen at that time, but at the time that you actually want to go forward and apply for a TRO, you should be guided by simply the hours of the day. So if it's in the evening after the courthouse has closed, or if it's on a weekend or a holiday, you can go to the local police department and you can ask to speak to an officer and make an application for a restraining order. So those individuals should not be telling you that you cannot make an application. I've seen too often, I've had a client say, well, I went to the police department and they told me that I should go to the courthouse tomorrow when it opens. That is not appropriate. That's contrary to our law, and police officers should not be doing that. Sometimes I think people are intimidated, and if an officer tells them that, they just kind of say, okay, and they leave. So I really encourage people, if that happens to you and you feel that you really need a restraining order, which I would hope you do, or you wouldn't be there, ask to speak to that person's supervisor, ask to speak to the desk sergeant that's on duty that evening. Or somebody who's higher up in the chain of command. Sometimes you're actually talking to that person, but I think it's less likely that a supervisor or a sergeant or somebody who's sort of in charge is going to tell someone that they can't apply.
Well, while we're on that, why don't we just go to number 2 on our list, which is what the process is at the police station itself. So let's say you go to a police station on Saturday night at 10 p.m. So what do you think is going to happen? I mean, you're going to meet with a cop, and maybe the cop says, "Oh, why don't you just go to the Superior Court on Monday?" Well, just understand, as Christina was just saying, they can't tell you that. You're entitled to be heard right then and there.
That's right. And, I would encourage anyone who is having that experience to just try to be firm and insist that respectfully, that you want to make your application, that you understand your right is to make an application, and that you can't be denied that right, even if it's 10 o'clock at night, and even if the officer thinks it's stupid, whatever you've told them has occurred, that if they think that it's not a restraining order, that's not for them to decide. It's not for the officer to make that call. They're supposed to take your information, fill out a formal application, and it's a little time consuming to go over all of the allegations, what you claim has transpired.
Right. And, you might be dealing with a cop who was, watching a baseball game, eating a bunch of donuts, and they don't want to actually take the time to do it. But I mean, once it's done, and I think we should make sure we're clear. At that point, you might be doing 2 applications. You might actually be doing a criminal complaint, and you might be doing the temporary restraining order. And the criminal complaint can be you asking for that criminal action, or the police officer can say, I want to do the criminal complaint as well. And they're 2 different things. We'll talk more about those later.
Yeah.
But once it's done, police officer is not the one that makes the decision.
That's right. They have an obligation to contact whoever the judge is that's on duty that evening and call them at home and bother them, but that's their job. That's what they're getting paid for. And they hear all of the information and they determine whether there should be a temporary restraining order entered at that time.
Right. And if the municipal court judge decides not to issue the restraining order, which, newsflash, they almost never decline to grant them.
Yeah, I think in the amount of time I've been practicing law, about 12 years, I maybe saw that happen once.
Yeah, I mean, the complaints that are issued in the municipal court usually have almost no detail on them at all, and it's amazing. They're granted no matter what. But if it's denied, you have the right to go to the Superior Court the next day it's open, the next business day it's open, and have your complaint reheard by a Superior Court judge. So you do have the right to have it reheard if you lose. But what happens, let's talk about the process. Let's say you're going to the courthouse to get a restraining order, which I think is more likely than not how most people get a restraining order, because they are under the misconception they have to wait.
Well, I want to add one other thing, though. If you go to the courthouse or you go to the police station to make an application for a restraining order and it is denied for some reason, the defendant doesn't know that. So the defendant isn't going to know that you applied for one and it was denied. Unless you tell them.
No, that's right. So if you go to this family division, you're gonna in most counties, and I stress to say most counties because some counties are small counties where there's really maybe only one judge in a small courthouse, where a judge may be the one that hears all parts of a temporary restraining order. But in most of the counties in the state, in all the counties in which there's multiple family part judges, 3 or 4 family part judges or more, almost every single other county has a domestic violence hearing officer. So the way that in most counties this works, and I'll tell you the difference between the small and the large, is you go in, you go to the domestic violence unit, and you fill out a couple forms. You'll meet with a domestic violence victim advocate. They're called different things. And they will actually fill out your complaint. They'll sit with you at a computer, and they'll sit and they'll type your complaint. You'll tell them what happened. You'll tell them what act of domestic violence was. You'll tell them what the prior acts of domestic violence were. You'll tell them what you're asking for. What do you we're going to talk about this a little bit later, but what are the things you're asking for?
Yeah, no, these are a series of questions that they'll ask you. You
Absolutely.
don't need to, have all of this memorized, but they'll ask you questions about these different things.
Right, and then after that's done, they'll take you to see the hearing officer.
Or the judge.
Or the judge. So if you go before a hearing officer, you're going to be put under oath, just like you would any other time, and you're going to have to testify as to all of the acts of domestic violence and the prior history. And the hearing officer will decide whether they're going to recommend a temporary restraining order to the judge or not, because a judge is the only one who can sign it, but they'll make the recommendation. Or you'll go straight to a judge, and the judge will make the call themselves. And if it's granted, then you'll leave the courthouse with a temporary restraining order. If the hearing officer denies your request for a temporary restraining order or declines to recommend one, you have the automatic right, much like at the municipal court, to immediately go and have a judge hear your case. So, and that's sort of how the process works at the courthouse. It really depends a lot of times on what time of the day you get there. I can tell you if you get there too late in the day, the courthouse closes at 4:30. If you get there too late in the day, like if you show up at 4:15, they're probably not going to hear you. They're probably just going to tell you to go to the police station to have it done there.
It is a state agency, a state entity.
At
so
4:30, there's smoke.
people are running for the door
Smoke
at
behind everybody.
4:29, 4:15 maybe.
Yeah, they're like in their seats, already have the bag packed, ready to go. I've had to tell employees that in the past. You work until 5, so 4:55 sitting at your computer with your bag packed, sitting at your desk is not appropriate.
If my secretary did that,
What would happen?
she would not be happy. I'd say, "What's the matter? You don't have enough work to do?
Yeah, but
I can find some work for you."
But no matter how you get the temporary restraining order, just keep in mind that you should only go get one when you really feel like your life is in danger, your health, your wellness is in danger, that you're actually scared of somebody.
And, it doesn't necessarily have to be you're afraid that they're going to kill you or
No, just hurt
physically
you.
harm you. I mean, there are some instances where if someone is really harassing you and you find their conduct alarming and it's really causing you significant inconvenience, that's a basis too to make an application for a restraining order.
Oh, absolutely. I mean, we see those cases all the time where someone will send 50 texts a day to somebody.
Yeah.
And really, that is harassment if there's other circumstances to warrant it. But when we come back after the break, we're going to continue going down the road of telling you guys how the TRO process works, and we'll try to get into a little bit more specifics about what you're going to have to prove and what you're not going to have to worry about. So we'll be back after the break. Stay with us.
Are you having fun running your business marketing? Or does online marketing and social media overwhelm you? Would you like to use Facebook, Twitter, Pinterest, Instagram, Snapchat, or LinkedIn, to name just a few online social marketing opportunities to market your business successfully? Amplify Your Voice can help. We work exclusively with local businesses in the PA&J radio target area of Hunterdon, Mercer, and Bucks counties, offering social media workshops, one-on-one coaching, managed services, direct online marketing, and web design. Contact us today at 973-615-5287 or email us at radio@ampyourvoice.com for a free no-obligation review of your online marketing. You can also visit us at www.ampyourvoice.com. Amplify your voice in a crowded market. Together, we will put the fun back in your business marketing. It's all authentic comfort food at Bitter Bob's in New Hope. Bob serves mouth-watering barbecued pork and chicken dishes, signature sloppy sandwiches, homemade cornbread, macaroni and cheese and collard greens, all the great southern dishes you crave for. Bob serves weekend brunch, lunch, and dinner, BYOB, with an outside patio that is dog-friendly, and he has a kids menu. Great desserts, too. And Bob can cater any event, big or small. Tell the waitstaff you heard this commercial and get 10% off. Bitter Bob's in New Hope, PA. Authentic comfort food for your family.
Welcome back to the Divorce Duo. When we left off, we were talking about number 4 of the top 10 things you need to know about temporary restraining orders. And number 4 on our list is the initial hearing. So you're at the courthouse or you're in front of a municipal court judge. So at the hearing, you're going to be making your application what we call ex parte, which just means you're the only one there. The defendant is not there. The defendant doesn't have an opportunity to say anything. And you're going to be administered an oath, just like you would in any other court setting. And you have to tell what the act of domestic violence was, what the history of domestic violence is between the parties, if there is any, the reason that your life, health, or well-being is endangered, whether there's any firearms or weapons present in the house or available to the defendant, and you're going to state the reason and the scope for any search and seizures that are necessary, and you're going to also talk about any relief that you're asking for in terms of support or the like. So the judge or the hearing officer is going to review everything. If you already have a case in the court, a divorce case or another kind of case in the court, they're going to take out your file and they're going to review it whenever they're looking at your restraining order, because a lot of times they want to know is there any prior history in the court. They may even look at prior TROs and FROs and see what's going on. So after they hear the testimony, they're going to either issue or deny a temporary restraining order, and they're going to tell you why. And if they grant a temporary restraining order, that's only temporary. It's only going to be temporary until the final restraining order hearing, which is supposed to happen within 10 days. I don't know the last time that there's actually been a hearing within 10 days. It's very rare.
I usually, if I find out, someone's retaining me or I have a client who has one against him or her, sometimes I see it where it is actually scheduled within a few days, but most counties will have DVs on every Wednesday or every Thursday or something like that. So if you get your restraining order on Monday, they'll probably just schedule it for, the Wednesday or Thursday that the court normally hears them. But I always find that very often they're postponed after that.
Oh, absolutely. So other than asking for the restraints of, not having the defendant contact you, what else can you ask for at the temporary restraining order?
You can ask for a variety of things related to custody and parenting time or custody child-related issues or support. So for instance, you can ask that you be designated as the custodial parent temporarily of any children, or you can also request that there be some parenting time provision for the other party. I don't see the plaintiffs generally do that very often, but sometimes they do. Or some other parenting time provisions. You can ask for exclusive possession of the home. And these are two that typically we see. If there's a child, generally the plaintiff automatically gets custody pending the final hearing and gets exclusive use and possession of the house. You can ask for some relief relating to exclusive possession of your vehicle. I don't really see that happen too often,
Yeah, I
but
don't
you
either.
can ask for that if that's a concern. You can also ask for some monetary issues to be addressed. For instance, we recently saw a case where our client was the defendant and the wife had asked for certain monies that the husband had withdrawn from a bank account be returned. And he returned those to an attorney trust account where they could be held. Sometimes people will ask for support. I don't generally see that happen too often, but you can ask for it. For instance, if you've got, if you have an ongoing divorce happening at the time, and there's a pendente lite order, meaning there's already been an order addressing temporary support issues, you can ask for that to continue in effect. I don't see judges too willing to go into a lot of detail about setting a new support award. You can ask for it, but I think, I would probably encourage against that unless it's absolutely necessary, unless you're going to have absolutely no access to funds or anything, to buy food or, pay normal bills. I think people generally should try to stay away from that a little bit, because then it starts to look like the application's not being brought in good faith and that you're really just trying to work the system.
Yeah, unfortunately, and this is not to minimize domestic violence because it is a problem, but I would estimate half of all TROs are entered for a reason other than someone's life or safety is being threatened by somebody else.
Yeah, very often you see these happen early in a divorce case. Maybe the people have just contemplated getting a divorce, or maybe they're getting a divorce already. They're involved in the process. And they figure out very quickly, maybe from their friends, maybe from their lawyer, that the only way to get the other party out of the house is to have a restraining order. So they look for every opportunity to file one. And
Yeah, he spit on me. I want a restraining order, and then she gets
or he's threatening me.
She gets the restrainer or whatever, and then her and her whole family are like,
Yeah,
I mean, they're laughing all the way because it's so easy to get a restraining order, as we've said several times. And again, I don't want to minimize that there are some very legitimate cases out there, but it's kind of like the little boy who cried wolf. I'm getting to the point now where I almost look at every case of domestic violence as not legitimate from the get-go, and I almost have to someone has to almost prove to me that it's legitimate, because I always almost already assume it's not.
Well, it's suspect if it happens in the context of a divorce, especially right at the beginning. The timing just seems suspect almost always, right? Mm-hmm. And I said earlier, it doesn't have to be some egregious act of domestic violence like physical abuse or something like that. Oh, this has driven John to drink. He's filling his glass.
I can't help it.
So we don't mean to minimize the person that actually is experiencing domestic violence in the home, but there are so many other people that truly aren't, and they really are just abusing the process.
But it's important to know that going in, because the judges all know that.
Yeah.
So if you've got a sort of a borderline case and you're going through a divorce, you're going to be met with skepticism from day one. From the second you go in. So just understand that.
Yeah, despite the fact that it's so easy to get a temporary restraining order.
Absolutely. All right, number 6 on our list is service of the temporary restraining order. And we'll just make this really quick. The defendant is not restricted from doing anything until they're personally served with the temporary restraining order. So that means somebody has to come and give it to them, it's usually a sheriff's deputy or a police officer. And they will, be personally served with the complaint. But until they're served with that complaint, it's almost as though it doesn't exist, because they have to be put on notice that there's a restraining order.
Yeah, and it doesn't count if you call them to tell them, or email them, or, the neighbor tells them, or your sister tells them. At least that alerts them to the fact that there's something going on. But until a police officer or the court personally serves that individual with the restraining order, they're not considered to be served. So if they were to call you and they haven't been served yet, that is not a contempt of the restraining order.
Right. I mean, and it doesn't matter where they live, whether they're in New Jersey or out of New Jersey. Just keep in mind it may take a week or more for them to be served. I mean, if they're in a different state, they're going to have to call wherever they are, wherever the defendant is, and find out what the procedures are for service in that location, and send it over. So it may take a while. So let's assume you're a defendant, Christina, and you've been served with a temporary restraining order. Do you have any rights before the final restraining order hearing?
Where are you going with this,
Can you try to get rid of the temporary restraining
Yeah,
order?
you have to be a little more specific. Sure, you have rights. If
Oh
your
my God.
constitutional rights.
She's only halfway through one glass of wine. Must be that Dayquil.
Yes, I did take Dayquil, and I don't know how much it's really doing for me right now. But yes, you can
Physically or
appeal.
mentally?
You can appeal the temporary restraining order, and this actually applies to both parties. If it was granted and the defendant wants to make an application to appeal it, that's allowed. And if the plaintiff was denied the restraining order, then he or she can make an application to appeal that as well. But basically, you go in front of a superior court judge, and you're entitled to have it heard. What lawyers like to say in legalese, de novo, which just means you're starting all over again. You're asking the judge to look at it anew and consider whether this is something that really should be granted. My question, though, I think often what happens when the defendant tries to appeal is the judge will just try to err on the side of caution. Even though we're kind of making light of these because very often people abuse the process, judges do want to err on the side of caution. No judge wants to be the one who denied a restraining order and then something really terrible happens, to the plaintiff. Like, I know this has happened where something was denied and the plaintiff was killed by the defendant very shortly after that.
It only takes one of those for every judge to be so.
Yeah.
But I mean, in reality, I mean, this almost is never successful. I think what you're trying to say is it's almost never the appeal of a defendant of a temporary restraining order is almost always denied. But it's important to know that if it's granted, that doesn't mean the temporary restraining order just goes away. What that means is the case is accelerated and the court's going to have an emergent hearing very quickly where the plaintiff and the defendant will both be there. So I always tell people basically it might be a way to have the final restraining order hearing quicker because that's all that's really going to happen. It's not entirely clear to me under the rules because this really hasn't happened in my practice, or I don't know. I think it hasn't happened in your practice either. I think we talked about this earlier.
Yeah.
I don't know in practice what that hearing looks like, whether it's a full final restraining order hearing or whether maybe the plaintiff just has to reiterate their facts. I don't know what it looks like, but just understand you have the right to appeal a temporary restraining order. Whether or not you're ever going to be successful, that's a whole different story.
I mean, I've never seen that granted. I've advised a few defendants of this opportunity, and they've done it themselves. So I don't even know what happened when they went to the courthouse. But in those instances, I think maybe there's 2 occasions I can think of. The judge basically just said what I was thinking is, I'm not going to hear this now. Maybe procedurally they did something, but I'm not going to hear this now. I want a full hearing. I want to hear from plaintiff. I want to hear from defendant, and I want all the evidence to be presented. So, and again, I think that's just erring on the side of caution.
Yeah, absolutely. So let's move on to number 8, which is violations of a temporary restraining order in contact. So what happens if you violate a temporary restraining order, Christina?
Well, if you violate it, meaning you've already been served, so you definitely are put on notice of the restraining order, and you do something in contravention of the order, like try to contact the plaintiff. I don't want to call them the victim, but sometimes that's how they're referred to. You try to call them, you try to email them, you go to the house, you try to reach them at work, you go to their place of employment, basically trying to make any contact with them. And that also applies to trying to reach them through third parties. You cannot try to communicate with them through someone else. Which means, I know she's close to my sister. I'm going to tell my sister, why don't you call her and tell her, hey, let's drop this. Don't do things like that. Don't have friends or acquaintances or relatives or anybody try to communicate with that person on your behalf.
And it's automatic arrest. Automatic arrest.
It is, although I have to tell you, I've seen occasions where things like that happened and you would alert the police and they, again, don't want to do anything about it because they just think it's silly. And I have to say, the occasions that it did happen that I'm aware of, I don't want to say they were silly, but, they weren't egregious.
Yeah, I mean, I always think of the situation where the plaintiff calls the defendant and then the defendant answers the phone and says hi, and she immediately calls the police and says, he communicated with me. Those are technically it's a violation. I mean, any contact at all, you would never be prosecuted for that, but you might be arrested. And that's really
You never know. Never say never.
Well, that's true. But, and it's important to note, we're just talking about the arrest. We're not talking about what penalties may occur because of the violation, because that's a criminal proceeding that would occur separately, which we're not going to talk about today. That's contempt proceedings, which actually happen in family court. They don't happen in criminal court.
But it's still a criminal matter.
Yeah. So anyway.
But another point I just want to make here that I think is really important from the plaintiff's perspective is that just because you are the plaintiff and you made the application, that doesn't mean that you can contact the defendant. You're not going to get arrested. It's not a contempt if you do try to contact the defendant, but the defendant cannot speak with you. So I see this happen a lot where plaintiffs think that they can initiate the contact and that all the contact is just on their terms. But you really can't do that because the defendant cannot have any contact with you, even if you initiate it.
If you want to have contact with the defendant, go and dismiss the restraining order because you're clearly not scared.
Yes. Yeah. So, that's another thing. I actually always love it when I represent the defendant and the plaintiff has contacted them because that's always my argument is how scared are you if you're contacting them?
It's absurd. So number 9 on our list is what happens in the time between the TRO and the final hearing. And really, this is the time where you're preparing for the final hearing, and your first question should be, do I need an attorney or don't I need an attorney? As an attorney, my sense is that almost everyone needs an attorney, but I actually think that if the plaintiff is not represented and the allegations are such that I'm fairly confident a judge would never issue an FRO based on what I'm hearing, I may tell them, go ahead and go to the court. And I may tell them to do one of two things. Number one, I may say if she shows up, he or she shows up, the plaintiff shows up with a attorney, you can always ask for an adjournment. And then the judge will grant you an adjournment and you'll be able to come back with an attorney. Or number two, just do the hearing yourself. The court is basically going to guide everybody and tell the two parties whose turn it is to talk, what the court wants to hear, and you can sort of do it yourself. And maybe you could use an attorney just as for advice on what you should say and not say, and what evidence you should have and not have.
I've done that many times for people who can't pay a retainer. They don't have several $1,000s to pay a retainer. And I'll suggest to them that if they're really uncomfortable doing the hearing themselves, they can meet with me for an hour or so, whatever time they can spend. And I'll walk them through the whole process and tell them what to expect when they get there, how it's going to work, what they should say, what they shouldn't say, what's important, different aspects of it that are important, because we're going through it here, but we're doing it very quickly. So sometimes people really appreciate that. It makes them feel a little more prepared.
Oh yeah, we're just scratching the surface here. The surface. We could spend a whole show on most of these topics. But you're also going to be gathering your evidence, figuring out if there's any police officers that need to come and testify, because they may have showed up on the scene. Maybe they're the ones that didn't see any bruises or any physical evidence that there was a struggle. You may be figuring out, is there any third parties that you can bring in? But importantly, a strange quirk of our system is that the defendant's not entitled to to ask any questions of the plaintiff or any of the plaintiff's witnesses, or ask what the plaintiff's going to be introducing at the final hearing. In other words, the defendant's not entitled to discovery.
There's no discovery in advance. Obviously so there's no misunderstanding. When you get to the hearing, you can cross-examine the plaintiff. You can cross-examine the witnesses. But prior to that, it's not like Law and Order, you don't have Kalinda on The Good Wife doing an investigation
God, I
for
want
you.
Kalinda.
I know, I want Kalinda too. But
Although I like the new guy too. What's his name?
well, I'm a little behind on The Good Wife, but you're really going in there cold. You don't know what evidence they have. You don't know. I mean, you might be able to sort of figure things out based upon the events the way that they occurred. But a lot of times, and especially as an attorney, we don't always know because our clients don't always tell us the truth. We don't always know exactly what happened. And sometimes we get surprises when we show up in court.
Absolutely, which is why we always try to resolve these cases if it's
Possible.
Yeah, and obviously if it's a real domestic violence case, we would never do that. But
Yeah.
it really depends. So number 10 on our list, lastly, is adjournments. So as we said a minute ago, a FRO hearing is supposed to occur within 10 days of the temporary restraining order being issued. And a lot of times it might be scheduled within those 10 days. But let's go through all the reasons it will be adjourned. Reason number 1, the defendant's not served.
That's true, yeah. So the plaintiff could show up and the defendant's not there because he or she wasn't served. Sometimes the defendant knows about it and shows up, and then at that point, the court will just serve them there, and you can proceed if you want to, or you can ask for more time to prepare your case.
Right. And then I guess number 2 would be, well, I mentioned it earlier, one of the parties shows up with an attorney and the other one doesn't have an attorney.
Yeah, that's generally the reason that it happens is someone shows up without an attorney and they've decided that they want to retain an attorney. And so I can't think of any instances where that was denied.
No, I can't either.
Unless you've been there 3 times already and, you can't keep saying, I want to get an attorney to adjourn. Eventually, they're just going to say, well, too bad, you had your chance. But that's usually when the adjournments happen. I don't think the court is as liberal in granting adjournments if you just show up and say you need more time, to whatever, gather documents or prepare your case.
Yeah, I agree. Although I feel like these days your first request for an adjournment is almost always granted.
Yeah, I think so. But I've had cases where I was litigating with another attorney on the case, and we would show up because we just couldn't agree on certain terms, that really, in my opinion, were more related to a divorce proceeding. And judges generally don't want to keep postponing them for that reason.
Yeah, I mean, it's you always have to be fair to the defendant. So, because
Yes.
they're entitled to a speedy hearing, and so.
Yeah, that brings us to another comment that I want to make is
Sure.
that if you are the defendant and you're coming to court and there's going to be an adjournment for some reason, regardless of who asked for it, if you want to ask for relief relating to parenting time, you should do that.
Absolutely.
Because that's one concern that defendants always have is that, well, as long as I have this against me, I'm not seeing my kids. So that is something that can be asked about of the court when you go, even if it's going to be adjourned.
Absolutely, it's a very important thing. So this really just scratched the surface. So we do have some blogs on our website that Christina wrote a couple months ago, and we're going to be putting them on our Facebook page over the next week. So tune into our Facebook page, and you'll see links to these articles, which have a little bit more detail.
That's right.
So now we're going to move on to war stories.
Yeah, so war stories. Oh, don't you have a lovely sound effect for us?
Yeah, well, you can start going.
I want to hear the sound effect.
I don't know what's going on with the sound effect.
Oh.
It's not, oh, there we go.
I don't know why that makes me so happy.
Well, because this is what it sounds like every day in our office.
Yeah, pretty much it does. At least that's what I hear in my head. I hear that too, all the time. So, war stories, we just try to give you a little glimpse into different things that happen in our practice. People love to hear these stories. I think we live such a glamorous, exciting lifestyle, right? As divorce lawyers.
Speak for yourself, Christina. My life is so glamorous. I can't even tell you.
I like to share these stories, though, because I know some people think that they're the only ones having a bad experience in the courthouse. And trust me when I tell you, whatever your story is, you're not the only one. And for instance, this week, we have a client who is not having a very pleasant experience in front of a particular judge. We're not going to say who it is, and I don't think I'm even going to say what county it's in. But this particular individual has really been getting hammered by the court. It's a custody issue, a parenting time issue, and it seems that every time we go to court, he just he doesn't get anything he ever asks for. And it seems that the mother in the case gets whatever she asks for. So we have different theories about why, but we don't have enough time to get into that. So this week, this particular judge signed an order to show cause, which is an emergent application. You have to demonstrate that if this order is not signed by the court, that there will be immediate and irreparable harm that will result. And so it's a very high standard. It's very difficult, or at least it should be very difficult to have one of these signed. And except under very limited circumstances, you do have to provide notice to the other side that you're filing this, and at least they have some opportunity to file something in response to it. So this particular judge, once again, just entered an order to show cause about something that really was not an emergency. She did it ex parte, which means that our client did not have any opportunity to respond, didn't know that this was even happening.
And the judge knew you were on the case, didn't even call you.
That's right. And we've been in front of the judge many times, so she knew that this individual had counsel. We didn't get a phone call. We got nothing. She entered the order, provided relief for the other party that, in my opinion, was just not appropriate. And if it had been appealed, if we had filed an emergent appeal, probably it would have been granted. And I've had this experience other times in front of this judge, and it's just very frustrating. Whenever these things happen, I always want to just fire off, like with those machine guns. I just want to fire off, an appeal. But
well, we can't always appeal, unfortunately.
that's right. But you do always have to consider, and we try to be mindful of this in our office, is that we want to do what's best for the client. So that means, trying to get them the best result that's possible under the circumstances and not costing them a fortune. So in that particular case, we chose to make an effort to try to resolve it rather than filing an appeal that would have cost a lot of money for the client, and we were able to resolve it in some fashion so that it was at a lesser cost to him.
Absolutely. Well, thank you for joining us today. I hope everyone learned a little bit of something about domestic violence. Next week, we're going to be talking about what happens at the final restraining order hearing itself, so you can sort of understand everything we told you today will probably be put into better context when we get to next week. So be sure you tune in and visit us on the web at centraljerseyfamilylaw.com. If you have any questions for the show, you can send them to us at divorceduo@gmail.com. And of course, you have been listening to PANJradio.com. We'll see you next week.
See you next time.